Welcome to part one of our series. What is a presumption? A presumption is not proof. It is not evidence. It is not a finding of fact. A presumption is a starting point. In law, a presumption allows a court to assume something is true unless it is challenged. Some presumptions protect fairness. The presumption of innocence, for example, requires the government to prove guilt beyond a reasonable doubt. But not all presumptions protect the accused. Some protect process, some protect institutions, and some shift the burden quietly without most people realizing it. When a court says, "We presume the judge knew the law," that means the record must clearly show otherwise. When a court says, "We presume counsel acted reasonably," that means the defendant must overcome that assumption. Presumptions are tools. They are meant to stabilize proceedings, but a presumption is not the same thing as proof, and it cannot replace constitutional guarantees. In this series, we are going to examine what happens when presumptions begin to stack. Because at some point, the question becomes simple. When law assumes instead of proves, what protects due process?